Hello viewers, Attorney Buado here. Welcome to the Criminal Law Jurist. When a Filipino commits a crime in a foreign land, will Philippine courts have jurisdiction to hear and decide the case? This is Episode 7, Article 2. We said that our criminal law is territorial in character. This means that a crime must be committed in the Philippines for our court to have jurisdiction. However, there are crimes committed outside the Philippines that can be prosecuted here. Conversely, there are crimes committed here that cannot be prosecuted here. The general rule in Article 2 of the Revised Penal Code is Philippine courts have jurisdiction over all crimes committed within the Philippines, its atmosphere, interior waters, and maritime zone. Exception: our courts have no jurisdiction, although the crime is committed here, where the offender is protected by laws and treaties of preferential application. What are these laws? In the Constitution, there is the so-called incorporation clause found in Section 2 of Article 2 that says, the Philippines adopts the generally accepted principles of international law as part of the law of the land, in effect, incorporating said principles in our statute books. What international principles affect our criminal jurisdiction? First is par in parem non habet imperium. Translation: all states are sovereign equals, and one cannot assert jurisdiction over another. It means that a foreign government, represented by its officials, cannot be sued in our court. So, if a Filipino was killed by an ambassador of another country, the ambassador cannot be prosecuted here because he represents his country. If he is sued in our courts, it amounts to subjecting his country to the jurisdiction of our court. In the same manner, the ambassador's country cannot also prosecute a Philippine ambassador who kills a citizen of that country. That is the principle of reciprocity. Second, international law principle that is closely related to par in parem is diplomatic immunity. Under this principle, ambassadors and diplomatic staff represent the head of state. Thus, they cannot be sued because of the centuries-old customary law codified in the Vienna Convention on Diplomatic Relations. Under this convention, diplomatic agents are vested with blanket immunity from civil and criminal suits. Example: a drug enforcement agent arrested an alleged Filipino drug trafficker upon authorization by the U.S. and allowed by the Philippine government. He was charged in court for violation of the right of the Filipino to due process and for the highly embarrassing way he conducted the arrest. The case was dismissed upon proof that he was authorized by his government with the approval of the Philippine government. A suit against him was a suit against the U.S. government, which is immune from suit. What about those crimes committed abroad where our courts have jurisdiction? Article 2 enumerates the 5 instances, and these are: offense committed in Philippine ship or airship, forgery of Philippine coins and currency, bringing into the country those forged coins and currencies, crimes committed by public officials in connection with their public duty, and lastly, crimes against national security and the law of nations. Those will be the subject of our next episode.